Hello friends, in the series on income tax cases, today we will discuss a very important case on the release of assets by the department in consequence to seizure of those assets in a search proceedings. The present case is on section 132B, subsection 1 clause I second proviso, which says that the asset seized should be returned back to the assessee after 120 days after last of the authorization has been drawn by the department in regard to such. The question before Delhi High Court in the present case was that whether this period of 120 days is a mandatory period or a directory period. This issue has been taken up by Delhi High Court in the case of Rajesh Gupta and others versus Assistant Commissioner of Income Tax, and this case is reported in 485 ITR at page number 97. The date of the judgment is 23rd December 2025. In the present case, there was a search on the assessee. The search started on 9th October 2024 and it continued up to 11th of October 2024. In the present search, total jewelry of rupees 5.39 crore was found by the department. Out of 5.39 crore jewelry, 1.51 jewelry was not taken up by the department, but the pending jewelry of rupees 3.88 crore was seized by the department. The assessee filed an application before the department on 25th November 2024 that the jewelry should be released to the assessee as per second proviso to section 132B subsection 1 clause I after 120 days of the last of the authorization drawn on the assessee. The department didn't reply and the jewelry was not given to the assessee. The assessee filed a writ petition in the Delhi High Court by citing the second proviso to section 132B subsection 1 clause I that it says that the jewelry or the assets should be returned back to the assessee after 122 days of the last of the authorization drawn. When the court heard the matter, the court said that the intention of the legislature in enacting section 132B subsection 1 clause I second proviso is that the 120 days should be calculated from the date of the liability determined by the assessing officer, and the period given in that second proviso is only directory and not mandatory. The court said that if the jewelry will be returned to the assessee and after that the tax liability will be determined, then the whole purpose of the seizure will be not fulfilled. So the court was of the view that since there is a provision that in case the tax liability is not determined or it is less determined, then the department has to return the assets to the assessee with interest. Since the assessee has every right to claim the interest from the date of the seizure, so in that case there will be no prejudice to the assessee, and section 132B subsection 1 clause I second proviso will operate as a directory provision and not mandatory. The court said that in the present case the court could not sit as an EO on the contentions of the assessee that the assessee's tax liability is not there. It is the assessing officer domain that he will calculate the tax liability after seizing of the matter when the assessment proceedings will start, and only when the assessment proceedings will be concluded, only then the tax liability will be calculated, and only then the assets of the assessee can be returned if the tax liability is less than the value of the asset seized. The court said that there is nothing which preclude the assessee in furnishing the bank guarantee to the revenue to claim his assets back, but as far as the second proviso to section 132B subsection 1 clause I is concerned, it is directory in nature and it is not mandatory. Friends, this case is very important as far as the concept is concerned that the assessee can claim the interest not from the determination of the liability but from the date when the assets are seized. At the end of this video, once again I am repeating the name of the case. The name of the case is Rajesh Gupta and others versus Assistant Commissioner of Income Tax, and this is a very recent judgment of 2026 which is reported in 485 ITR at page number 97. The matter has been decided by Honorable Delhi High Court on 23rd December 2025. Thank you, friends.